Hi all, I hope you're well today. So, have you been following the big legal showdown that's unfolding over the National Guard deployments? It's one of those moments where law, politics, and power all collide in ways that could reshape how America handles domestic crises. Today, we're diving into what's going on between the federal government, several states, and the Supreme Court, and why these cases could have massive consequences for years to come. Let's talk about it. So, here's the situation. The Trump administration has been pushing to deploy National Guard troops in cities like Chicago and Portland, even though state leaders there are saying no. The goal, according to the administration, is to protect federal property and maintain order, especially around immigration and customs enforcement facilities. But the states argue that there's no chaos or rebellion that would justify bringing in troops. They say this isn't about safety, it's about control. And now, the courts are being asked to decide who actually has the final say when it comes to using the Guard inside U.S. cities. In Illinois, the Department of Justice asked the Supreme Court to let the president federalize and deploy National Guard troops around Chicago. The administration says it's a necessary step to enforce immigration laws and protect federal operations. But a federal judge in Illinois blocked that move, saying there was no credible evidence of rebellion or violence that justified such an extreme action. An appeals court agreed with her, and now the administration is asking the Supreme Court to step in. If the court rules in favor of the White House, it could dramatically expand presidential power, not just for this administration, but for all future ones. Meanwhile, over in Oregon, the story has been just as tense. The federal government tried to send National Guard troops into Portland after claiming that federal property was under threat. But U.S. District Judge Karen Immergut issued restraining orders blocking those deployments. She said the administration's claims about the city being in a state of emergency were, quote, untethered to the facts. The Ninth Circuit Court initially overturned one of her orders, but another one is still in place, keeping those troops from being sent in. So basically, we've got this tug-of-war between federal and state authority, and it's playing out on multiple levels at once. Now here's where it gets really interesting. The legal argument behind these deployments comes down to an old law, 10 U.S.C. Section 12406. It says the president can federalize the National Guard when the laws of the United States cannot be executed by ordinary means. Sounds simple, right? But what does that actually mean? Who decides when that threshold is met? The president? The courts?
Or the states themselves?
And here's the million-dollar question. If the president alone can make that call, what stops any future administration from declaring an emergency and sending troops into any city it wants? This is why these court cases matter so much. They aren't just about Chicago or Portland. They're about the boundaries of presidential power. Legal scholars are already warning that if the courts defer too much to the president's claims, it could open the door to much broader use of federal troops inside the country. Imagine a future where presidents can deploy the military domestically whenever they say there's unrest, without needing a governor's consent. That would fundamentally change how America balances state and federal authority. On the other hand, some people argue that the president should have that power, especially in moments when states are unable or unwilling to enforce federal law. They say the federal government has a duty to step in if local officials fail to keep order or protect national interests. So it's a tough debate. How do you draw the line between protecting federal property and overstepping into state sovereignty? It's also a question of precedent. The Supreme Court's decision, even if it comes through a short emergency ruling, could set the tone for how future presidents use the National Guard. If they side with the administration, it could strengthen executive authority over the Guard. If they side with the states, it could reaffirm that governors have the final word unless Congress explicitly says otherwise. Either way, it's going to shape how power is distributed between Washington, D.C. and the states for a long time to come. And let's not forget the human side of this. These aren't abstract legal concepts. They affect real communities. If troops are deployed, how would that impact local residents, businesses, and protests? Would it calm tensions or inflame them further? And what does it do to public trust when federal and state governments are openly battling each other over who controls the military? Those are the kinds of questions that go beyond law. They go right to the heart of democracy. We're now waiting for the Supreme Court to make its next move. The justices could issue a decision any day now on the Illinois case, and whatever they decide will almost certainly echo in Oregon and beyond. Meanwhile, state and federal lawyers are preparing for more hearings, more appeals, and possibly more political fireworks.
So, what do you think?
Should the president be able to override a governor and send in the National Guard whenever the federal government sees fit? Or should that kind of decision always require state approval? Let me know your thoughts in the comments. I'm genuinely curious how you see this balance of power playing out. If you enjoyed this breakdown and want to stay updated on stories like this, where politics, law, and power collide, make sure to hit that like button, share the video with friends, and subscribe for more. Thanks so much for watching. Stay informed, stay curious, and I'll catch you in the next one.